final speaker today is Ingrid Landau. She's a dear friend and colleague from Monash University. I want to plug the fact that she has a book coming out very soon on the history of the human rights movement and human rights due diligence laws, looking at why they've come through the UN process and now through the EU and not through the ILO, where we might think of them coming from. So quick plug for Ingrid's new book. We're going to put the name of it in the chat. It's not out quite yet, but it will be soon. And Ingrid, welcome and thank you so much for speaking tonight.
Thanks, Shelley, and appreciate the plug for the book. So what I thought I'd do is, in my comments today, is just try and link this discussion with the report that I and colleagues have released as part of this event. And this report addresses kind of the risks and the opportunities that we see arising from the trend towards mandatory human rights due diligence. And I'll just briefly address why we've written the report and some of the key takeaways. As Shelley noted in the introductory remarks, the report's been written by a motley bunch of us who work in the field of transnational labour governance. But what drew us together and motivated our writing of the report was a shared concern over the trajectory of due diligence legislation in the global north, and a shared concern with the presumption that further legalisation of human rights due diligence will necessarily improve conditions for workers and unions. And our report, while we refer to the EU directive, the proposed directive throughout, is written with a view, I guess, to potential regulatory developments, not only in the EU, but more broadly. So we recognise kind of the momentum around due diligence laws and the massive efforts that have gone into securing these laws in a number of countries and through the European Parliament. And we recognise the positive impacts that the laws already in place are having in terms of shifting kind of normative change and thinking around supply chain responsibility and prompting business to take action where they otherwise may not have. But we argue that there's really very little evidence to date to suggest that mandatory human rights due diligence laws are delivering for workers. And they tend to be privileging process over outcome, failing to address key barriers to workers seeking remedy in the context of transnational supply chains, and importantly, failing to to establish appropriate regulatory architectures. Moreover, kind of these laws risk not only failing to challenge, but kind of actually endorsing and promoting prevailing corporate practices in which companies kind of unilaterally choose what labour standards to focus on, the extent to which and how they will address them, and the extent to which and how they'll consult and when they'll consult with workers and unions. And these laws also run the risk, I've seen a lot of conversation about this in the EU context, of endorsing social auditing, despite evidence demonstrating its significant limitations. Of course, we're far from the first or the only ones to point out the limitations in existing or proposed due diligence laws. And there's great work being done by NGOs, the international trade union movement, and scholars, among others. But as Shelley mentioned, where we've tried to make a contribution in our report is by way of the perspective that we bring. And we draw on our kind of diverse experience and expertise with national labour laws in multiple jurisdictions, as well as with worker-driven approaches to improving labour standards in global supply chains. Shelley also mentioned we kind of bring a perspective that challenges the notion of workers as kind of passive beneficiaries of corporate-led programs. And we see workers' human rights breaches in global supply chains as rooted in the exploitation of power disparities, and the need to address these through economic, social, and legal means. And this perspective also sees workers as kind of active agents of change and emphasises the need for approaches that recognise and create and protect spaces for workers to organise and to engage in collective negotiation and collective enforcement of context-specific and dynamic labour rights and standards. Recognising not only the risks, but the potential for human rights due diligence laws, we try in our report to offer guidance on how human rights due diligence could be legislated in a way as to drive meaningful change for workers. We offer 27 recommendations, which I'm not going to go through now, but I'll just touch on a couple of the key points. First, we do address, the need for the scope of these laws to be consistent with, at the very least, the UNGPs and OECD guidelines. And this, of course, refers to the types of companies which are covered, the rights that they cover, including critically, from a labour perspective, freedom of association and collective bargaining, and the reach of the due diligence requirements throughout the supply chains. We emphasise the need for human rights due diligence laws to secure greater transparency and traceability of corporate supply chains. We know from experience that the knowledge of how a supply chain is structured and the identity of businesses within it are among the most powerful tools in transnational labour organising. So we need due diligence laws that promote, that require companies to trace their supply chains and make this information publicly available. And in our report, we advocate for an approach in which the law would set out general obligations, and specific requirements would be determined on a sectoral basis. Thirdly, and critically, as has already been touched upon by a number of speakers, due diligence laws need to go further than simply exhorting companies to meaningfully engage with workers. Evidence on corporate human rights due diligence practices to date, for example, findings from the Corporate Human Rights Benchmark, and from decades of experience in labour law, tells us that companies will not consult adequately and in good faith unless they're legally required to do so. So we advocate to be meaningful. These obligations need to be mandated, and they also need to be enforceable by those who are intended to benefit from their requirements. And these requirements for consultation should exist at all stages of the due diligence process, and with respect to the development and the implementation of company grievance mechanisms. Here, in this context, we also see an important role for worker-led kind of binding and enforceable agreements, and for multi-level collective bargaining. And we think these types of initiatives should be recognised and promoted in due diligence laws. My fourth and second final point goes to the nature of human rights due diligence itself. As others have mentioned, I think Ruan mentioned in particular, these laws must move beyond a focus on process and be more oriented towards outcomes. And we argue that they should impose positive duties on entities to respect human rights or to do no harm in their own operations and supply chains. And so effectively that due diligence be established as a standard of conduct. These duties should be non-delegable. So companies should not be able to contract out of their primary duty, including by way of passing responsibility on to suppliers, or by way of reliance on third parties such as auditors. We do recognise that failure to discharge the corporate responsibility to respect human rights should lead to obligations on companies to remedy any harm caused, and in certain circumstances to give rise to civil liability. In respect of civil liability, we advocate for a shared burden of proof between the claimant and the defendant. So once the claimant establishes a prima facie case, the burden shifts to the defendant to demonstrate that they've taken all reasonable measures to prevent the harm. And this approach is, of course, taken in many areas of national law, including employment law and discrimination law, which are essentially analogous contexts where the complainant lacks access to the requisite information to establish the breach, and a lower and shared kind of standard of proof is necessary to achieve the statutory objectives. And we also argue for recognition of joint and several liability, an approach that recognises and has a potential to kind of distribute liability for harms among players in the supply chain. We recommend another range of other ways that human rights due diligence laws should make claims less costly and more accessible to workers. And we'd like to see them going significantly further than they have done so in terms of if they address the myriad of practical and legal barriers that effectively prevent transnational claims from succeeding and that we've seen to date. My last point just goes to the regulatory infrastructure. And of course, getting this right, we think is as important as getting the substantive obligations right. The absence, and you see this particularly in modern slavery laws in the UK and Australia, but the absence of accessible and effective state-based oversight and supervisory mechanisms has been a key driver of poor outcomes to date. So the imposition of due diligence obligations must be accompanied by robust monitoring and enforcement mechanisms. We need supervisory authorities that are independent, properly funded, that have expertise in labour-related matters, and given a wide range of investigatory powers. These state-based mechanisms must also be complemented by mechanisms through which workers and their representatives can bring allegations of non-compliance. State authorities should be empowered to impose a wide range of sanctions, including administrative penalties, enforceable undertakings, and exclusion from public procurement. The report covers lots more, but I'll finish up there. Just to conclude, we see there are risks implicit in seeing human rights due diligence as either a panacea to either preventing labour rights abuses or to holding businesses account for harms caused. And we caution against a focus on human rights due diligence at the expense of alternative and more promising approaches, including sectoral bargaining agreements and worker-driven social responsibility agreements. But we argue that if and where appropriately crafted, due diligence laws can play a positive role in opening up spaces for workers, trade unions and others to challenge prevailing corporate practices and to access remedy. Shelley, have I gone over time? I'll stop there.
Thank you so much, Ingrid. I thought you were extremely succinct. I would love it if we had time for our speakers who are still with us to stay on for a little bit to answer a couple of questions. I think Heidi has had to run and I can't see Isabel, but Ingrid, Ruan and Jeff, if you would be interested in answering some of the fantastic questions we have in the chat, then that'd be really wonderful. We've got a question about where interventions are working most effectively. And I thought, Ruan and Jeff, you might be interested in answering that. It's a question from Rory O'Neill, who says, where do you see interventions working most effectively? Collective bargaining, bilateral agreements, procurement clauses, multilateral banks, labour, social and environmental standard clauses, normative measures, and you might want to add something else. What are our most effective tools in the toolbox, Ruan and Jeff?
Thanks, Rory, for the question.
Yeah, thanks, Rory. That's it's $1 million question. I mean, I think from our perspective, certainly we're engaged in all of trying to promote compliance and pushing for labor rights in all of those fora. So it's certainly each aspect is part of the wider jigsaw, I would say. So I don't know, Jeff, you want to add anything on prioritization?
I don't know about prioritize. I mean, I don't know if in that list, I don't have it in front of me, if it included trade agreements and other trade-related measures. I mean, that certainly has been a mechanism that, again, has its limitations, but has been used in the past to try to secure at least legal reforms, if not lasting reforms in practice. So with the rapid response mechanism in the USMCA has, I think, had some promising results. But I think we need to find leverage where we can find it to open up the space for organizing and collective bargaining. So I'm not sure that I would say one is any better than the other. I think let's pursue all the angles.
Mm-hmm. This is a question that I think, Ingrid, you could answer, or Ruan and Jeff. It's about how we measure whether there's been an acceptable level of participation by workers' representatives. At the moment, that's not an aspect of human rights due diligence. I certainly think that something that we might be interested in. But what's your view about that? Ingrid, do you want to start, and then maybe Jeff and Rona, if you've got anything to add?
Yeah, I guess my first point is that it needs to go beyond the company deciding, what is adequate consultation. I mean, that would be an improvement in itself. I guess I think how we measure it is that we make it enforceable, I guess. To me, is a key way that is not going to measure it, but it is going to allow challenges where it has been seen as inadequate, I guess, to challenges the adequacy of it. And ideally, I'd like to see some kind of dispute, some kind of body, or kind of with a potential to kind of conciliate and resolve disputes over things like exercising the right to consultation. So I'm not sure that that answers the question, but I think it's kind of approaching the question from a different angle, if that makes sense.
Yeah, sure. And it, may become an issue in legal claims where a company has to demonstrate that it's conducted adequate human rights due diligence. And, that could be part of the evidence that's brought forward. Ruan and Jeff, do you have anything to add about what is an adequate amount of consultation with union and worker stakeholders?
Yeah, sure. So I think that the German HRDD law, in fact, goes in the right direction on this by requiring Works Council involvement in the risk mapping exercise, and also for the Works Councils to be part of the grievance mechanisms. And a key role that the Works Councils play will also be to consult with workers and workers' organizations from around the world so as to inform the risk mapping exercise. So that in itself is a form of the Works Council signing off on the HRDD plan, on the risk mapping plan. So just as we're calling on for directors' duties, for directors to sign off, workers and their representatives should be able to sign off. So that could be a form of proof in terms of meaningful stakeholder engagement with trade unions, at least. Then if we look at the language of the 2018 general OECD HRDD guidance, we managed to secure some pretty good stuff in there in terms of what stakeholder engagement means, which includes entering into direct agreements with global unions. That in itself should be proof of meaningful stakeholder engagement with unions if you sign off on one of those agreements. And this is also something that we've proposed, and maybe I can share that in the chat, what we produced probably about 5 years ago now, which is our 8 core principles for effective HRDD laws. And one of the things we advocated for was trade union and worker involvement in any oversight bodies. Now, if you have worker involvement in an oversight body that looks at the implementation of the HRDD law, then that also is a form of ensuring that there's worker involvement and participation in the implementation phase that's outside of the company itself. So maybe that's also another area that we could look at.
Mm-hmm. Jeff doesn't want to add anything. Last question, and I've had a question that's been sent to me privately, as well as the question here from Mr. Nguyen. Mr. Nguyen's question is really about how we address the question of informality. And relatedly, the question that was sent to me privately is, most of the time we see formal workers that are in large workplaces, maybe workers in factories, who are organised and making claims. But where the worst human rights abuses occur is generally for workers who are in smaller workplaces, and often informal workplaces, ones that might not be in a registered business, but will nevertheless be in the supply chain of an international or transnational business. Do any of you have views about how to address that problem with informality, and in particular, how to ensure that workers who are the most vulnerable, who are most likely to have egregious human rights abuses, are able to access rights under human rights due diligence laws? Ruan and Jeff are looking at each other. Ingrid's not leaping in.
No, but I think there's a point made in the report. Like the due diligence needs to go throughout the chain to the entirety of the production process, right? So we shouldn't be looking just at the point of final assembly, right? We need to be looking at the inputs and mining or harvesting or whatever supply chain we're looking at. It needs to look at kind of all the sites of production, and particularly when and there's an excellent point. I mean, it's the ones that are going to be the kind of most risky from a human rights perspective are going to be those. I mean, it could be any point in the supply chain, but very likely to be those that are less regulated, less monitored, less inspected, and it's certainly going to be those workplaces that are, in some cases, intentionally left out of legal frameworks, intentionally left out of business structures, for the very purpose of being able to exploit the labor. So, yeah.
And yeah, I'm just going to add. Obviously, agree with all of that. That this is, obviously a very, very pertinent question, because I think this morning the workers' spokesperson in the opening of the ILC mentioned the fact that there's almost 65% of the global workforce works in the informal economy. So this really is the major question to address when we talk about workers and supply chains. And again, going back to the question around the sources of rights and sources of law that inspire this legislation, ILO recommendation 204, of course, is a critical piece in this. And it places, not obligations, because just a recommendation, but advises states, but also employers and businesses on what to do in that transition. And I think a critical piece is also transparency, and in the risk mapping exercise itself, something we'd previously called for was for brands to look obviously beyond tier 1 and tier 2 and try and identify the types of employment relationships that exist in their supply chains. And of course, we'd also be interested in the levels of trade union density and collective bargaining coverage. But that mapping exercise should be able to show the level of informality in their supply chains. Because if certainly we're not talking about employees of suppliers and these are workers in the informal economy, they should be able to pick that up. And by picking that up, they should be able to address that risk. So that mapping phase is key. But to be extremely realistic on the outcome side, on informal workers actually using HRDD laws, this again is very difficult. So we work with a number of informal workers associations from around the world. Let's say traditional trade unions are also now engaging or trying to organize informal workers, but this really is a key issue, and there's no easy answer there. But at a minimum, it should be incumbent on all lead firms to do their mapping and to identify how many informal workers are in the supply chains, and to also identify specific geographies. So in terms of risk prioritization and how to address salient risk, they can focus on those vulnerable workers.
Great, thank you. Well, this seems like a great point to wrap up the event. I just want to ask the authors of our report to show themselves. Auret, I can see you. Ingrid, Hila, Tamar, Judy, I've seen that you've joined us, but you haven't had your camera on. But welcome and congratulations on the report. To our speakers, two of our speakers have had to leave, but Ingrid, Ruan and Jeff, thank you so much. Everybody who's been here for the fantastic questions and comments online as well, thank you. Please, if you can, take yourself off mute and join me in thanking everybody. Please do.